Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name is Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about accessory after the fact. But before we get to that, don't forget to click like on this video if you're enjoying it. And if you're enjoying all these videos, don't forget to click subscribe with a little bell next to it to be notified of future videos. Accessory after the fact. There is a difference between being charged with committing a crime or helping somebody else to commit a crime. That's a different video. I'll put it up here when I get to that. Haven't done that video yet. Today's question is about accessory after the fact. So let's start with the definition of what that is. When you hinder, delay, prevent the discovery, detection, apprehension, prosecution, conviction, or punishment of another for the conviction of a crime, you render assistance to that person, right? So in other words, if you know somebody's committed a crime and you're helping them either to get away with it, to hide the evidence, or to avoid prosecution in some way, that's when you're going to be charged with an accessory. I've personally not seen too many of those cases where you're being charged with a misdemeanor for helping somebody cover up the crime of a misdemeanor. Usually prosecutors care about this type of thing when it is a felony, and usually it's a serious felony. But let's look at the actual statute so we can see what it says. So 18.8.105, accessory to a crime. And remember, accessory to a crime is in itself a crime. And so section 1 is what I read to you before in the answer slide, but that's what it is. A person is an accessory to a crime if they do any of those things. Notice to render assistance is very specifically defined here, to harbor or conceal, to warn a person of an impending discovery or apprehension, to provide the person with money, transportation, weapon, disguise, etc., force, intimidation, deception, to obstruct anyone in the performance of an act which might aid in the destruction, or to conceal, destroy, or alter any physical or testimonial evidence. All of those things would be a chargeable act. And the level of the charge is specific to the charge that you're helping them with. So in other words, if it's a class 1 or 2 felony, which is an extremely serious felony in Colorado, it will be a class 4 felony with a presumptive sentence of 2 to 6 years. If you are charged with helping somebody with a class 5, 4, or 3 felony, it would be a class 5 felony. And if it is a class 6 felony, it'll always be a class 6 felony, and then the misdemeanors are also misdemeanors. So in other words, if you're helping somebody hide the evidence of a misdemeanor assault, that would also be a misdemeanor. And again, it's gradated based on the charge that you're being charged. It's gradated on the charge that the principal, the person who actually committed the crime, is being charged with. So if you know that they committed a crime and you help them in any of those ways, you will almost certainly be charged with a felony, you'll be charged with a crime, especially if it's a felony. So don't do that. That's pretty bad. And if something seems amiss, you're almost always better off not giving the aid or assistance, because if you're charged with the crime, they have to prove you knew that a crime had happened. But under the circumstances, if they think they can charge you, they may have circumstantial evidence, that's not direct evidence, that you committed this act while knowing that the person had committed the crime, right? So that is the question and answer for today. If you would like your own question answered on a future video, you can always put it in the comments below, email me, or tag me on Twitter. And as always, you have a right to remain silent. If a police officer asks you questions about what you have, know, did, where you've been, anything, you have a right to say, I don't want to talk to you. And if they persist, you can always ask for an attorney.